What are the stages of a trial? We're not talking about the whole litigation process. We're just talking about the stuff that's on TV, the in-courtroom trial work. Let's talk about the stages of a trial. I'm Mark Lyda from Lyda Law Firm. Let's get to work. Okay, so in another video in this playlist, we talk about the stages of a lawsuit. So that's the early initial stages where you're trying to work something out, where you file a complaint, where you have service of process, you go through the whole discovery process. It's really a long, drawn-out process, and you don't see that on TV. But in this video, I just want to talk about the phases of the trial itself. The trial is like the grand finale for that whole drawn-out process of the lawsuit. So, what happens when you actually get to the courtroom for the trial? Now, there are two types of trials. There are bench trials where the judge is the only person there, and then there are jury trials where the jury actually decides what's true and what's not true. Let's talk about a jury trial. The first stage of a jury trial is jury selection. If you've ever had jury duty, you know what this is like from the other side. The lawyers each ask the jury questions to try to figure out who can be, first, a fair and impartial juror, but secondly, a good juror for them. And they go through a whole process of striking the jurors they don't want, striking the jurors they think will be biased, etc. Oftentimes, lawyers try to sneak in like their arguments about the case and their case theories into the jury selection process, so watch out for that too. So that's the jury selection phase. The next phase is opening statements. During opening statements, each side, they don't argue or say, here's why you should find for us. They're supposed to just say, here's what we allege happened. Here is our side of the story. First the plaintiff goes and then the defendant goes to give you their side of what they expect the evidence at trial to show the jury. After opening statements, the plaintiff puts on its case in chief. That means the plaintiff, the party that initiated the lawsuit, can call all of their witnesses, present all of their evidence. Maybe it's, written contracts or email records or bank records or whatever, and they present all of that to the jury. After that, the defense puts on its case in chief, where it does the same thing. It calls its own witnesses, and while each side calls their own witnesses, of course, the other side has a chance to ask questions of those witnesses as well. So you hear from both sides, even during the other side's case in chief. You'll hear from the defendant during the plaintiff's case in chief, and you'll hear from the plaintiff during the defendant's case in chief. After each side has put on its case in chief, the plaintiff can then put on rebuttal witnesses if it has something to say to rebut something that happened in the defendant's case in chief. And you can kind of go back and forth with rebuttals until the judge gets impatient with you and cuts you off maybe. After all of that is closing argument. The plaintiff goes first, then the defendant, and then the plaintiff can go again to have the last say. And during closing arguments, that's where the lawyers from each side have the chance to really argue their case to the jury, not just say, here's what the evidence will show you, but here's what the evidence showed and here's why we won. And they really put on their advocacy hats. That's usually a lawyer's favorite thing to do, is to do that closing argument where they really have a chance to try to convince the jury of what happened during the trial. Then the jury goes back to their room, they deliberate, and they come out and they deliver the verdict. Then after that, depending on how you feel about the verdict, there might be appeals, etc. But those are the stages of the trial itself, the main event of a lawsuit. Thanks for watching, and please remember to click like and subscribe to help keep legal education accessible for small business owners.